afternoon, good evening. I see some people are still trickling in, but the numbers are slowly stabilizing, so we might as well start. So welcome to this webinar on AI and data privacy in the workplace, which is a collaboration between the OECD and Ius Laboris. As we all know, artificial intelligence is making progress at lightning speed. It's increasingly being used in the world of work. And in many cases, this will lead to increased productivity, better working conditions, and perhaps even higher wages. In fact, from a 2022 OECD survey carried out in the manufacturing and finance sectors of 7 OECD countries, we know that both workers and employers are overwhelmingly positive about the impact of AI on work. But there are concerns also. And one issue is that the increased use of AI in the workplace will likely result in greater collection and analysis of data on both workers and job applicants. Now, in some cases, data on workers is collected as a byproduct. It's not the main purpose of the AI system. In other cases, AI systems may be specifically designed to measure productivity or monitor workers. And the kind of data collected may include information such as tasks completed, speed of completion, worker movements, but even biometric data or online activity. And much of this data is, of course, personal in nature. In addition, AI may be used to infer personal data because it makes it easier to extract, to re-identify, and also link various pieces of information. So workers may rightfully worry about their privacy. They might also worry that the data collected are used for purposes other than for which they were intended. And increased monitoring and surveillance in the workplace could also it will lead to more stress. In fact, we have evidence backing some of this up. The same survey I already mentioned showed that most workers who reported AI-related data collection in the workplace expressed worries about this data collection. In particular, over half of workers whose data was collected felt increased pressure to perform. They had privacy concerns. They were worried about bias in automated decision-making, and they thought that data collection may be unnecessary. More recently, the OECD carried out a survey of 6,000 mid-level managers in 6 countries on algorithmic management tools. So in other words, tools that give instructions to workers, but also monitor and evaluate them. And we found that the use of such tools was already very common. 90% of US firms adopted at least one of such tools, 79% in Europe and 40% in Japan. Again, we need to remember that such data collection can have benefits. In the same survey of algorithmic management, 60% of managers said that these tools had improved the quality of their decision-making, and often that was driven by increases in the information available to managers to make decisions. But at the same time, despite the widespread adoption of such tools, we know that the protection of workers against privacy risks varies considerably across OECD countries, and that gaps remain even in those with the strongest protections. So many OECD countries have data privacy laws, like the GDPR in Europe, but there are a number of reasons why it's hard to regulate workplace privacy through such general privacy laws. First, employers often rely on supposed legitimate interests for monitoring workers, and that makes it difficult to decide what is acceptable and what is not. Second, there is a power imbalance implicit in the employer-employee relationship, and that casts doubt over the meaning of consent in such settings. And third, in the employment context, there are also collective rights to information, and these rights often tend not to be covered in general data protection regulations. Now, of course, it should be remembered that the collection and use of workers' personal data can be regulated through laws other than privacy law, such as labor law, for instance, or indeed through collective agreements. So what we hope to do today is to dig a little bit deeper into AI and privacy issues in the workplace and ask the question of how well the current law protects workers. And to do this, we have with us a number of legal experts from the Ius Laboris network. And for those of you who are not familiar with Ius Laboris, it is a global alliance of law firms that specialize in employment and labor law. So who's better placed to tell us what the law says about these issues? Now, before we start, just a few housekeeping issues. The webinar will be recorded so that we can make it available on our website afterwards. And also, please use the chat function to ask questions. There will be some time towards the end of the webinar for the panelists to answer some of those questions. But now, without further ado, let me move to our first speaker of today, who is Burkhard Gupfert. He is a partner at Ius Laboris' German law firm, and he has worked in Germany, Poland, and Asia. He leads and coaches on negotiations, particularly with works councils, and based on which the legal press has called him the architect of labor negotiations. So, Burkhard, can you tell us a little bit more about the current legislative landscape in the EU when it comes to workplace privacy and AI?
Lovely. Thank you very much, Steen. Thanks for this marvelous opportunity to mingle with your folks on policy issues, which is really challenging. And it's a kind of a premiere on our side, so we're really happy to do this. I'm from Europe, so from the highly regulated zone of law in this respect. And I won't reiterate all the legal regimes that are applicable here. You mentioned GDPR, we have the AI Act, we have the Platform Directive, and in particular, we have a wide range of co-determination rights, which empower Works Council and unions, at least to obtain a certain degree of transparency. Of course, we see in the global conflict zone that we all are very well aware of, a certain tendency to require and request deregulation, which also affects the European Union. I think we have all seen this. The question is, where will this lead us to? My personal prediction is that we will probably try to limit the extent to which documentation is required, in particular by smaller and medium-sized companies. So it's more the documentation requirements and less the level of protection. I think that is an important message. When we look at our particular topic, I believe we're currently very much focused on regaining the rule of law in an area that is more or less unknown territory to all of us. I mean, everyone who's using AI is basically using and improving it by the day. And also the systems that will be made available in HR and outside of HR basically depend completely on artificial intelligence, information bundling. So it's an unavoidable fact. We are very much focused on the question on gender bias and other bias within those systems at the moment, which I think from a European standpoint are more or less covered by the applicable regulations. Where I see some necessity to look into at the moment is the whole matter of profile building, because although a lot of systems may be designed to obtain information on the working regulation, working methods, and also the reaction of employees in their workplace on their matters that they work with. But at the same time, in the backyard of AI, we are building up a profile on each and everybody. And that also applies to the workplace. And this, I think, is at the heart of workplace privacy, which we may have to focus from a policy standpoint. Now, what are European companies doing at the moment? Because quite frankly, if we look at the rule of law, the rule of law is always as good as the legal system, and the legal system is always as good as the courts. But the courts are completely overwhelmed and helpless in addressing AI issues, even understanding them. And not to say they are too slow to act in accordance with the fast development of this technology. So I think it's a lot of self-binding regulation that we see at the moment. I have particularly focused on a few international companies in the European theater who have started with collective agreements. I think this is a very good approach to bring in the social partners into the discussion. We have seen first tariff agreements even on collective agreements with the union in Germany on the usage of AI. And most recently, and I think that is something that we all need to have a look at, there may even be something like international obligations created under a Paris process, where first larger German companies are currently evaluating the text in order to see whether they can sign this. And this comes very close to a movement that we've seen as a global union movement, where collective agreements have been signed on a global level with as kind of a self-regulated regime, which then in turn gives certain rights in front of courts if you are not confirming your obligation that you signed on a global level. So that is quite effective. So unfortunately, I believe on one of the key topics that is on the privacy side, which is the slow building up of profiles, we may be lagging behind, and we should be focusing on this also from a lawmaker's perspective. But not surprisingly, from my end, my part of the world here in Europe, highly regulated. We are quite curious to see what other jurisdictions can bring to the table, where maybe new ideas are being born that we all should be looking into and listening to. So thank you very much for having the start in this webinar, and I think I'll be summarizing a few of those thoughts later as we move on in the webinar. Thank you, Steen. Yeah.
Thank you, Burkhard, for giving us a European perspective. So now we will move to a completely different part of the world, Singapore. And our next speaker is Rajesh Srinivasan, who is a partner and head of technology, media, and telecommunications law practice at Ius Laboris, a Singaporean law firm. And he's also the coordinating partner for the firm's multidisciplinary and cross-practice data and digital economy legal services. Rajesh, tell us a little bit about what the situation is in Singapore.
Sure, certainly. My pleasure. And thank you for all of you as well for your attention today. So over here, far away in Singapore, what we've been looking at in terms of AI is a bit of a crossroads environment. As you may know, Singapore is very much a jurisdiction where we see influences coming in both from the east and from the west. On the area of AI, our policy making in particular in the context of employment related areas takes into account a few key characteristics of our country. Firstly, if you know Singapore and you're familiar with it, it is a multi-jurisdictional society. And so cultural differences, religious differences, racial differences often need to be well protected and is protected to an extent under our constitution as well. And so when it came to looking at artificial intelligence, this became a very important aspect. In terms of the mechanics on this, there are two key areas that we need to look at from an employment perspective in terms of AI and deployment of AI. Firstly would be our data protection legislation, and secondly would be our AI governance framework. We did not go as far as some jurisdictions in terms of passing an AI Act. Singapore strongly believes that, as of now, because the risks are still manifesting, it would be a little bit premature for us to come up with an act. And so what we did instead was to come up with two strategies which are relevant from an employment standpoint. First, the governance framework that is basically a set of core principles which we first launched a few years back at the Mobile World Congress in Barcelona at an international fora. And since then, we are now at version 2 of the governance framework. The governance framework basically sets out best practices in terms of collecting and using data, processing that data in AI systems, maintaining a degree of transparency, and in particular from the perspective of employment, to ensure that principles of ethics, no bias, and fairness are also enshrined in the manner in which AI systems are designed, developed, deployed, and then used by the end users themselves. So again, these are core principles. The governance framework itself does not have the force of law, but it is intended to slowly become legally enforceable. What do I mean by that? Well, as the risks manifest, then the laws will come to pass. So for example, in Singapore today, there is a serious concern with regard to deep fakes and misinformation and disinformation. So at a surgical level, specific laws have been passed to prevent any such acts from being carried out using AI systems. And of course, sometimes these AI systems are also used to harass individuals online. So we have Prevention of Online Harassment Act and other forms of Online Falsehood and Manipulation Act, which we passed. And these acts, again, surgically addresses the actual risks themselves. So while not AI specific, they address the legal risks in terms of misuse of AI systems in an employment context. The other area, as I mentioned, is privacy. And when one looks at privacy, in Singapore, we do not have privacy enshrined in our constitution. It's not a constitutional right. But we do have a Personal Data Protection Act. And again, that's by design. The design being one of ensuring that there's a balance between the rights of employees and the rights of responsible employers who use the data for specific purposes, which they've notified their employees about, and the use will be on that basis alone. And if there's a new use, you need to get fresh consent. So on that basis, if one were to look at it again in the context of AI systems, the reality is that we need to ensure in designing these AI systems that and deploying the AI systems that you do get adequate consent from individuals prior to the deployment of these AI systems. And that's in line with the data protection consent requirements. But at the same time, there is a little bit of push when I, for example, as a lawyer, advise my clients on this. They come back and say, well, Rajesh, there's no privacy law in Singapore. So, and I can't have a camera, for example, put in a workplace to capture people, supposedly doing work, right, in non-sensitive areas. And you can't fight against that because there's no privacy law. So surely the same principles ought to extend, let's say, to the AI systems. Well, I tend to take a cautious approach on this front. Firstly, because the law is still developing. Secondly, the manner in which AI systems manipulate data, use data for your benefit, and sometimes maybe not for your benefit, are just being crystallized now. In particular, in employment, the use cases are only just being developed as we speak. The tools and the solutions are very much at version 1, version 2. So with that early stage, I think it would be wise for employers to still seek consent, only because the Personal Data Protection Act already requires you to get such consent to use the personal data of individuals. It would very likely be the case in most HR-related AI usage that personal data of employees will be a key part of the data set. And so logically, take that logical road and get the necessary consent using the same mechanisms that organizations already have to put in place because of Personal Data Protection Act. So those are the two big areas that we have the privacy laws and we have the AI governance laws. And I'll come back later and talk a bit. Thank you.
Thank you, Rajesh. And now from Singapore, we go all the way to Canada. And our third speaker is Sonia Regenbogen. Sonia is a partner at Ius Laboris' Canadian law firm and who has dedicated her practice to collective bargaining, employment agreements and policies, advocating before arbitrators, human rights tribunals, labor relations boards, and the courts. Sonia, last time we spoke, you told me the situation in Canada is a little bit complex. Can you tell us more about this?
Definitely. So I think there's two main points. One is that there is no specific legislation in Canada that addresses AI and data privacy for either employees or consumers and members of the public. Back in June of 2022, the federal government introduced a bill to be debated in government with a view to passing that would address these issues. It was called the AIDA. And as a result of the proroguing of government now and the upcoming federal election, that legislation has been stalled. And what practically would have to happen with a new government is new legislation, either similar or completely different, would have to be tabled when the new federal government is put together. No provinces in Canada have enacted any kind of AI regulation either at this time. So the second important point is that Canada has a federal system where we regulate certain aspects vis-a-vis federal regulation, and federally regulated employers like banks, telecommunications, broadcasting, for example, are subject to federal employment law and federal privacy law. So we have a federal act called the Personal Information and Protection of Electronic Documents Act, PIPEDA. It's a mouthful. That is privacy legislation that would apply, that would include any information collected by generative AI with respect to employees. However, as mentioned, that only applies to federally regulated employers and their employees. At the next level, generally speaking, labor law and privacy law is governed provincially. And there are 3 provinces in Canada that have introduced their own privacy legislation. That's the provinces of Quebec, Alberta, and British Columbia. So if there is a private sector employer operating in those provinces, there is privacy legislation that would also govern the protection of privacy interests of employees vis-a-vis AI technology. However, having said that, those are the only provinces that have provincial privacy legislation. Ontario, one of Canada's largest provinces where I live in the city of Toronto, has no privacy legislation that applies to private sector employers, with the exception of a Health Information Privacy Act. So you can see that Canada has, number one, no sort of overriding AI and data privacy legislation that applies to all employers. And instead, we have a patchwork that is determined in part by the jurisdiction in which you operate as an employer, but also is specifically still governed on those older models of business use, consent, those sort of older ideas around privacy vis-a-vis employee protection. The one interesting thing is in the province of Ontario, the government has been somewhat responsive to the general public and workers' concerns around AI. And it has introduced an amendment to an Ontario Act that governs employment law to specifically require employers, if they use generative AI or any other AI tools or algorithms in recruiting and assessing candidacy for employment, that has to be indicated on the job application. So that information has to be put out there proactively. The other attempt to be responsive to concerns is that employers who have more than 25 employees in Canada or more have to have what's called an Electronic Monitoring Act. Now, that new law doesn't create any privacy rights or new protection, but what it does is it requires the employer to communicate to employees how it is either tracking or collecting information about employees in the workplace, including by use of AI, but also any technology, such as tracking devices or surveillance, for example, electronic or otherwise. So those are 2 recent developments that are generally attempting to be somewhat responsive. But really, at this time, we have this patchwork, and for the most part, has not been designed to address generative AI.
Thank you, Sonia. So we've heard from 3 countries or regions, and we've seen that there's quite a bit of difference between them already in terms of the coverage of existing or the existence of laws. I'd like to take a step back now because we have with us Alex Milner-Smith, who is a real expert in this. He chairs Ius Laboris's data privacy expert group. He's the co-head of the data privacy and cyber practice within Ius Laboris's UK law firm, and he advises on the adoption of global privacy strategies and a comprehensive range of data protection and privacy issues, including AI and governance strategies. Alex, can you help us get a bit of perspective on it, on all this, and perhaps look also at the points of commonality, because we've seen differences, but perhaps there are points of commonality between these 3 countries, perhaps with other countries too.
Yeah, thanks very much, Stijn. Pleasure to be here. It's a large topic. I'm short on time, so I won't have any preamble, but I will try to cover 3 things, just touching base on a couple of other countries, draw out some universal principles, and then just see where there's a gap that potentially someone like the OECD could fill. I'm not talking about the UK today, but just in case anyone is interested, we're much more like Singapore, an in-between point between, say, the apparent US federal laissez-faire approach and perhaps the slightly more conservative EU approach. I will say that the UK data regulator, in some of their first papers, has specifically focused on AI and data in the workplace, and equally the government's Department for Science, Innovation and Technology produced a paper last year on recruitment data and AI. It's a genuinely good piece of work. and actually has lots of synergies and synchronicities for anyone around the world. It's a paper well worth reading, whether you're in the EU, Canada, US, Singapore. I will talk about the US for 1 second because it is important. We have to think about the federal position and the state position. In the US, it's certainly true with the new administration, there's been a rowing back of the federal position. One of the new administration's first actions was to revoke Joe Biden's executive order on safe and secure and trustworthy development of AI for federal agencies. And of course, many people had spent 18 months building governance programs for AI and AI in the workplace in relation to work they do for federal businesses or within the federal government. Equally, just only last week, 2 memos came out, both of them, one accelerating federal use of AI through innovation, one driving efficient acquisition of AI. Both of them are not focused on regulation. They are much more focused on more the laissez-faire innovation and speed. But when we look at it at a state level, there are actually general laws, the Colorado AI Act, but there are lots of state laws which focus specifically on workplace and data and the AI and AI usage. So the New York State Law 144 is very, very restrictive on the use of recruitment tools involving AI, where you have to be transparent, you can't have any bias. This is very similar to some of the things that Burkhart was saying earlier. Equally, Illinois, with its Illinois Video Interview Act, similar protections, and its Biometric Act, again, restricting the use of biometrics within the workplace. And then finally, a state that we don't often think about, but an important one, Maryland has released new guidelines specifically saying, do you know what, you're probably supposed to say Maryland, but Maryland, employers must be transparent and follow ethical guidelines and obtain employee consent when they're going to use AI tools in relation to facial recognition. So although we have a federal rowing back, from a state perspective, it's very much state by state in the US. And that actually leads me on to drawing out, dare I say, some universal data principles in relation to the use of AI in the workplace. There's some differences. Rajesh was talking earlier quite a lot about consent from employees for the use of AI. We obviously in Europe with the capital E might not necessarily use consent. But in general, I and a number of other regulators around the world, there are some 5 or 6 key principles that do apply to the use of AI in the workplace from a data perspective. The first one being transparency and fairness. It's not rocket science to understand that as per GDPR and UK GDPR and other laws around the world, employers have to be transparent about their use of AI systems. They have to allow employees to understand how decisions are made, give the possibility of challenging those decisions as necessary, potentially even giving explanations to employees and unions and works councils about the logic involved in any automated decision making and any AI that is used to build out processes. And on that note about automated decision making, it's not new that automated decision making, both under GDPR and other bits of legislation around the world, is quite restrictive. You are only supposed to make decisions based on automated decision making where you have an exception or a safeguard can be relied on, if it's necessary for performance of a contract or you have consent. This is an old money data law that now does clearly apply to lots of the AI technologies that we are deploying in the workplace. For instance, an AI recruitment tool. We need to be careful and navigate whether or not we are falling foul of data laws around the prevention of use of automated decision making. Equally, a corollary of that we see all across the world is the need for human oversight, and even more important in the workplace context. Yes, you can use these tools, but from a data perspective, there needs to be a human in the loop at some point, not only to give an opportunity for employees to question decisions, but also to monitor whether these decisions are correct or biases are emerging. And then it's almost finally, security and data minimization. Stin, at the start, you mentioned that the use of AI is potentially necessitating the use of more and more and more employee data, whether that's during active use cases of looking at AI within performance management or recruitment, or it's within the training cycle many of our clients have come to us saying we are sitting on large data sets of employees. Can we possibly use these data sets to either build our own AI models, or use various models that we can purchase from OpenAI and so on to actually create things? Now, of course, that raises all kinds of questions. Have we been transparent? What's the lawful basis? But this is something that I think every jurisdiction around the world is dealing with. The desire to use employee data to create new tools, improve tools, and of course, respecting the fact that why have we collected that data in the first place? Can we still use it? And the final point I want to make, different jurisdictions around the world have a variety of different individual data rights, from subject access rights to the right to erasure. Many of these are deployed in the workplace. They all still apply in relation to the use of AI. And although it's not a workplace specific example, but we have seen in Austria, the Austrian DPA is challenging OpenAI at present because they couldn't affect a data subject's right to erasure. So if we transliterate that across to the workplace, what if one of our workers, it could be in Hong Kong, they have data rights. What if they file a data subject access request asking what data of mine is within your tool? Provide it to me. Can we do that? I don't know. This requires a new way of looking at things. But it's something that synergistically is all around the world. So there are a few differences, as I said, in relation to lawful bases. But in the main, I think there are more commonalities than differences. And then what might the gap be? Where perhaps can the OECD step in? As I said, it seems to me through a data lens and certainly through the AI lens, there are more similarities than differences. There's certainly a commonality of language between jurisdictions, even in the US when we look at it at a state-by-state level. And I think a body like the OECD is frankly well placed to come up with a set of AI and privacy regulations in the workplace that companies could follow, and that might give them comfort that if you do that, you are potentially more than compliant in X number of countries. I'm not going to say the number of countries because obviously there would be nuances. One can make, just to play the case of devil's advocate, the usual point that more regulation stifles innovation, but I'm not sure I necessarily agree with that in this point. You can imagine if there was that transnational set of AI in the workplace rules, uniformity would have great benefits. We see inconsistencies and fragmentation in current national laws, despite the similarities. And when you remove that fragmentation, have uniformity, I think there would be more AI technologies developed at a certain standard that I think would give employees comfort. That then brings me on to my next point. I think there would be enhanced trust. Adhering to recognized international standards can enhance trust and credibility, creates a stable environment for innovation. But from an employment perspective, trust in the workplace, be it directly with employees or unions or works councils, is absolutely crucial. And then finally, rather than stifling innovation, I think simplified compliance. We act for many, many multinational businesses who operate in 20 jurisdictions or even 100 jurisdictions. They are always wanting to make calls about what is the foundational level that we have to follow here for our workplaces. It is very difficult to have 50 different nuances or 100 different nuances. So there is space here for specific legislation, I think, or a specific body like OECD to release guidance on, AI and data in the workplace. And, I hope it's something that after this call, we potentially talk further about. But that's where I'm ending for now, and I'll be answering some questions later, I think.
Thanks a lot, Alex, for I think it's a really useful overview. And how can I disagree about roles for OECD? From this kind of global perspective, I'd like to go back maybe to the national perspectives that we heard earlier. And I want to ask each of our previous speaker perhaps what they see as some of the main gaps within their kind of country or territory. What are the main challenges and the main gaps going forward? And perhaps we can do it in reverse order this time, and we can start with Sonia.
Certainly, thank you. So clearly in the Canadian landscape, employment regulated AI governance remains underdeveloped. The efforts in this regard obviously have stalled, and it's contributed to a fragmented regulatory landscape. So a little bit about what Alex talked about on the global level, the uncertainty involved in regulation between countries. Well, that even exists within the country, insofar as it's possible, much like the US, you can have both the federal and instead of states, we have provinces, but you have that province-based regulation. And so this really is, I agree with the comments that Alex has made, is, generally employers view more regulation as challenging. But the gap in this regard is actually perhaps presenting the challenges. And what we've seen in Canada is a turn to, let's call it soft law or non-binding guidance. And so when the Artificial Intelligence Act died on the vine, so to speak, within the political process, there was the Ministry of Innovation, Science and Industry announced the publishing of a voluntary code of conduct on the responsible development and management of advanced generative AI systems. And that was back in September of 2023. That provided a set of principles and commitments for companies to voluntarily sign on to. And when you became a signatory, that information was then publicly available. And so we can see that we have at both the sort of federal level, this voluntary code in particular that is setting out best practices. And also at the provincial level, the provincial privacy commissioners' offices are publishing principles on the responsible and privacy protective generative AI technology uses and creation. So there are these various sources just at the national level of soft law, if you will. And I think in terms of that is a real area in which at the global level, a real contribution could be made to this development of best practices, recommendations, policy focus, so that there was a clearer understanding of how to navigate this as an employer, but also potentially in the creation of AI systems and the further development of the technology. I think Burkhart said this well, we're sort of, and I think Rajesh mentioned this also, this idea that we're on, version 1.0 or maybe 2.0. And so at this time, how can the development of these systems benefit from a clearer guide regarding, at the very least, best practices? So can soft law work to fill this gap that exists at this time?
Thank you, Sonia, for that perspective. Rajesh, what about in Singapore?
Yeah, so over here, as I shared, the concern is not to overregulate an industry that's just starting to really make an impact. Now, I know that many would disagree with that because of the pace at which AI is moving, right? That one should not talk about giving time when we don't have time and we must act now. But I would still urge some degree of caution because overregulation can lead to unexpected outcomes as well. And so what we've tried to do in Singapore is really to try, and I'm perhaps going to focus a bit now on issues and gaps in particular in the Singapore context, and perhaps maybe even broader Asian context. The first key concern, as I mentioned earlier, is because of the multicultural issues that we have here in Singapore, the concern with regard to output inaccuracy, because AI systems can produce false, inaccurate outputs. To what extent should employers rely on the output of AI systems? For example, when it comes to down selection of potential candidates for specific jobs. And to some extent, the training of these AI systems, should employers have some say as to, or some visibility and transparency as to how the systems are created? And because employment is such a, cultural thing, meaning, different organizations have different ethos in terms of how they bring people into the organization, how they treat the individuals, how they, get the best out of each of their employees. Should employers not play perhaps a greater part in the creation and the design of the AI systems itself? So the question then is, what's the best mechanism for this to happen? Should it be hard law? Should it be regulatory frameworks, best practices? And here again, Singapore's crutch has always been, let's go for the regulatory framework approach. Find a set of, in Singapore's context, we have this thing called the Compendium of Use Cases, which I would commend all of you to have a look at. It's literally, you have to search for Singapore Compendium of AI Use Cases and it'll pop up on your screen. If you go into that and you look specifically at the employment-related use cases, that's where you'll see how companies who've been struggling to try and find this balance have come up with internal best practices. For example, in terms of training personnel to always have human oversight in any AI decision-making process as a mandatory requirement, right? So you don't just take what AI systems give to you at face value, as good as it may appear at first instance. Accepting the fact that errors can occur, and so these risks need to be managed. The other area of concern that I have seen is in the area of personal data again, and the fact that you need to have specific strategies in managing personal data usage in AI systems in a HR context. The reason for that is, as an employee, sometimes you do need to share rather sensitive information, in particular, healthcare related information, which employers do need because employers do need to take out insurance. And without access to this very sensitive information, they won't be able to get the best insurance cover. And I am aware of some AI systems today in the employment context that have a scoring system which takes into account issues such as, oh, okay, how many days did this person take off on medical leave and how much did they consume in terms of medication, and weightage applied in the context of assessment of performance. So here you have now AI with regard to existing employees being used in such a way that impacts on the assessment of the employees and by extension the remuneration that these employees receive. Again, the challenge here is the usage of this personal data. If it is being used in a way that negatively discriminates against such individuals, what recourse can there be for such individuals? I say again, employment is very much a cultural thing in a microcosm. Every company has certain thresholds, and certain industries may have a more sensitive reaction to this, and others may have a less sensitive reaction. So again, looking at the fact that there's a massive difference in the approach taken by companies across different industries, the regulators were sitting down and scratching our heads saying, look, there's no one model that actually works from a hard law perspective. And so my expectation in Singapore is that we'll continue down this road of governance, best practices, training, capacity building of individuals, and perhaps slowly mandating some of these human oversight obligations in particular in the context of employment. Again, this is purely my speculation, but we're certainly seeing some messaging from the regulators on this front that this is a big part when it comes to employment, that this data not be used to negatively discriminate against individuals, and if so, that the organization through a responsible individual takes responsibility of the output of these AI systems.
Thanks, Sujesh. Burkhard, you have the final word from Europe. What do you see as the main gaps here on the old continent?
Three observations. First one is deregulation is not for the sake of deregulation. So we need to keep in mind that just the examples that Rajesh was showing from Singapore, where we believe maybe the least regulated market, show us that a case-by-case analysis of issues will bring us closer because it's content-focused rather than procedural-focused. The second observation is, and you could see this from some of the comments that we've seen in our chat, I personally believe that we need to rethink AI, we call it 2.0, 3.0, and we may need to think it less from a GDPR principle perspective. Alex mentioned the question of simplicity and foreseeability and also the vastness of data that is being used. We could see from the comments in the chat that the whole concept of consent is basically collapsing in front of AI. And we cannot really talk about consent here. If people are required to use this in their workplace, consent becomes more of a vain key buzzword that doesn't really cover the issues. And we could see from Singapore in particular that a topic-focused approach may be the right one, where I strongly believe that bringing in social partners, in particular, where we have them, like in the European scenario, where we have unions and works council also strongly regulated, that we encourage not only self-binding, but binding regulations between social partners on the uses of AI. But in that case, focused on real topics like the ones we mentioned. I personally believe that the profile building is a real strong topic and a gap that we need to look into. And at the same time, also the question of the special protection of minorities, which is always at the heart of lawmakers and us lawyers. Just to think of the protection of minors and at the same time the protection of people with special handicaps in the workplace, where we need to look into whether they are particularly misused in the scenario of AI. And I think that this can be done better in a cooperative manner with our social partners rather than on a self-imposed, purely a self-binding approach. So I think I strongly believe in regulation here, but maybe we need to rethink the GDPR focus because it may lead us not really to cover the topic here.
That's really interesting, Prakar. Thank you. I realize that I'm an economist, you're all lawyers, and we have been talking about the people who are really affected by this, which is the workers and the employers. So I now want to turn to both the Trade Union Advisory Committee, to the OECD, and business at OECD to ask the worker and employer perspective on some of the issues that we've been discussing. So first we have Sarah Jameson. She's a senior policy advisor with the Trade Union Advisory Committee to the OECD, where she's responsible for policy work related to AI, digitalization, and she's also worked as senior program officer for a global human rights NGO and as a lawyer for the New Zealand government, including on issues related to data privacy. Sarah, can we have Tuak's view on some of the issues that we've been discussing today?
Thanks, Stain, and thanks to the organisers for the opportunity to share some brief thoughts from a trade union perspective. So I guess starting from a basic premise, from a trade union perspective, it's really crucial that as AI advances across workplaces, that workers and job seekers have a legally enforceable right to access, rectify, and erase the data that is collected about them, and a legally enforceable right to object to and restrict the processing of personal data, and crucially, that they're able to exercise these rights in practice. So as was mentioned earlier by panelists and in your introduction, these rights are in some contexts to some extent provided for in both national data protection legislation, but also in national human rights legislation, as well as being guaranteed in legally binding international human rights treaties, which give governments obligations in this regard. However, while existing data protection legislation and human rights legislation has the potential to provide protection to workers in the context of increasing data collection, there is in many instances currently a lack of clarity as to how these specific provisions are to be interpreted and apply in the specific context of AI use. So, for example, one of the specified lawful bases for the processing of data by an employer set out in the GDPR is that such processing is necessary for the performance of the employment contract. And has yet been minimal case law, and there's no legally binding guidance on what necessary means. And with that in mind, there's potentially a risk that a very wide range of data processing could be viewed as lawful simply by virtue of AI-powered technology being used in the context of the employment relationship. The same point applies to the legitimate interest basis for data processing referred to in the introduction to this webinar, and as also to the balancing exercises that are required in many of the domestic human rights statutes guaranteeing the right to privacy. Clarity regarding how existing rights and obligations apply in the context of AI is crucial for workers and their representatives to be able to exercise and enforce their rights. it's also essential to give employers certainty regarding their obligations. And from our perspective, this clarity and certainty can only really be achieved through legislation, whether that's amending or updating data protection legislation, where it exists to reflect and address the particular issues posed by AI, or through new legislation, specifically addressing the various issues posed by AI use at work. The EU's Platform Work Directive is an example of how this could be achieved in the sense that it addresses various issues ranging from data protection to occupational health and safety. Alexander referred earlier to the importance of transparency. And this is a key priority for trade unions around the use of AI in the workplace generally, but it appears particularly pertinent in the context of discussions around privacy and worker consent. Even before AI came on the scene, there were long-standing questions regarding consent as a lawful basis for processing, specifically when consent can really be said to be freely given in light of the power imbalances between the employer and worker. And as the OECD has recognized, these power imbalances are exacerbated by the use of AI in the workplace context. Transparency over the specific AI tools that are being used and how is essential if workers are to be able to exercise and enforce their rights. Beyond this, however, we also emphasize that transparency is also essential to building and maintaining trust, which was also emphasized earlier as being crucial to innovation and to a mutually beneficial and productive working relationship. I'll wrap up by echoing the comments made just before by Burkhart, sorry if I've mispronounced your name, regarding the important role to be played by collective bargaining in this area and highlighting that trade unions are actively engaging on this topic. So there was a survey carried out last year of 148 trade union representatives on collective bargaining regarding the use of AI tools at work. And data protection and worker privacy was found to be the issue most frequently addressed in collective agreements and the most negotiated topic in discussions outside of formal collective bargaining. I'll leave it there. Thank you.
Thanks. That last point, especially about what trade unions are concerned about when AI is adopted in the workplace, resonates. It's things that I've heard before. So thanks for confirming that. And so last but not least, we will turn to Emma Brierley, who is a policy manager at Business at OECD and responsible for their work on employment, labor and social affairs, economic policy, governance and regulatory affairs, as well as competition. Emma, how do employers see the issues that we discussed today?
Thank you, Steen, and thank you very much for the invitation to join today's webinar. I mean, from an employer's perspective, the use of AI in the workplace has great potential to improve business performance. And just as we saw with the digital transformation of our economies, data enables organizations to identify trends, to streamline operations, and to make more informed decisions that are ultimately to the benefit of employers and employees alike. In this context, today's webinar was very helpful in that it provided an overview of the laws and the regulations that do already exist in many OECD countries to uphold data privacy. And in our role, representing business and employers at OECD level, we are working with governments and other key stakeholders to advance the trustworthy use of data and AI across all sectors. And what we are seeing as AI is increasingly being adopted by companies, including in the context of human resource management and training, we see that businesses really believe in the value of evidence-based OECD instruments that have been developed through multi-stakeholder dialogue. And I'm talking about things like the OECD AI principles, the OECD privacy guidelines, and the OECD recommendation on enhancing access to and the sharing of data. We believe these instruments are an important basis to advance good data and AI governance, including that relevant data is collected lawfully and transparency. Employees are informed about what's collected and why, and data is securely stored and its access is limited. Today's webinar and the discussion here also show that there are some gaps and some countries in which the level of data privacy standards is lower. And it is really critical for businesses that are operating across jurisdictions to have these types of effective data governance frameworks in place that are coherent, and more broadly, that this type of dialogue and global cooperation on relevant data governance issues continues. So I'll be very brief and conclude by saying that we believe that in order to harness the potential benefits of AI in the workplace, this needs to go hand in hand with good data governance, and that continuing to work with the OECD to advance cross-cutting evidence-based analysis and guidance through multi-stakeholder dialogue is crucial to advancing trusted digital innovation and trustworthy AI in the workplace. So thank you, Steen, to you and your team for organizing today's discussion.
Thank you very much, Emma. I see that some questions have been posted in the chat, but before I turn to those, I was just wondering whether, Burkhard, you might want to summarize some of the main takeaways for policymakers from our discussion today.
Yeah, happy to do so. I think starting from a point made by Sarah, looking at the Platform Workers Directive and the way in particular this is being designed with regard to transparency and employee representation involvement may be one of the starting points for regulators, because there we have quite exemplified and detailed regulation that is being used, by the way, when we do collective bargaining agreements these days or self-binding regulations in the European Union. We are focusing very much alongside the regulations of the Platform Workers Directive. The second observation may be that the good old principles of GDPR may not really be working in the area we're looking into here, because the whole consent discussion, I think we need to put this to a rest and understand that policy making based on consent may not be, or a consent requirement may not be the state of the art anymore. And last but not least, I'd really like to advocate the approach of our Singaporean colleagues. Why? It's not only because this is one of the most modern societies in the world, and by the way, also one of the most multicultural societies. At the same time, you're taking a step-by-step approach based on real issues that are immediately being tackled. So I think lawmakers may want to have a look at a more process-style regulation that allows social partners, for example, or governments to come up with fast solutions on identified issues, rather than trying to cover this piece of law by general regulations like the GDPR principles, which then may not really prove to be suitable for the completely different data set that we're talking about here. So these are my three takeaways from this discussion. I've seen questions, Steen, and you may want to look at them. Some of them we have covered. I could see this, but maybe there's a few left that we can cover in the last minutes of this webinar. Thank you very much.
Thank you, Burkhard. I couldn't have done a better job. So I will pick up on some of the questions. One thing this is a question asked very early on, a question about case law. And are there, in the countries that we have covered or maybe elsewhere, some interesting case law examples that have come up? So not just talking about regulation, but about case law, which might be regulating some of the things that we've been discussing today. I don't know if anyone wants to chip in here.
I can give it a start. I was giving a quick answer in the chat already. At this stage of play, we will only see first instance case law, if at all. And this case law is particularly critical with regard to the use of evidence to bring information that has been obtained about an employee, for example, in a violation of works regulations that is collected based on data and IT tools that use artificial intelligence. And there we have a great reluctance of courts to admit this in evidence. So these are the first indicators. And I believe that we will see more of this coming because there is a certain distrust. I mean, in your initial statement about your report, you showed that there is a certain, I wouldn't call it distrust, but cautiousness of people when using AI, and the same applies to our courts. And this is what we can see in the first instance rulings that are available now. But I think it's premature to say that there's a vast variety of case law. I don't know, Alex, anything to add from the UK perspective, maybe?
Yeah, sure. There's absolutely thousands of case law decisions in the UK, so I can't go through them all in common law jurisdiction. But there are lots and lots of case law at a very senior level, European Court of Justice of decisions, on automated decision making, which does apply to AI, the boundaries of what is a solely automated decision, when an automated decision earlier on in the piece assists the human later. These are all relevant, although I take Burkhart's earlier point about, is GDPR necessarily fit for purpose for modern technology? But equally, I was very interested in Sarah's comment on the boundaries of performance of a contract, which is a crucial thing as well, and it still will be within AI. There isn't much guidance from a workplace perspective per se, but there is, of course, an enormous European Court of Justice decision on a company, the name of which I won't say, but relating to personal advertising and the scope of necessary performance of contract, which is actually quite restrictive. And so by analog, you would draw it out. But of course, I'm a common law lawyer, so I'm better at drawing things out by analog, perhaps. Not better, it's just the way our system works. Equally, there are various decisions on employee monitoring, say from the CNIL as one example, in relation to a large company, about proportionality, the need for such monitoring, which again can be drawn by analog to looking at certain uses of AI in the workplace. So in terms of decisions specifically on AI per se, within the modern parlance, perhaps not, but there are lots of decisions where you could take inspiration from. But of course, not all of us have the time to take that inspiration, and not or take Emma's point about what businesses might need, that you can't all be looking at 15 different cases and working out your own principles. But I think from an underlying perspective, there is lots of case law if you're interested.
Thanks, Alex. Burkhard, I know that you wanted to bury the issue of consent, but I just want to bring it up once more because it has been mentioned in the chat. And I was wondering whether any of you know of examples or can think of ways in which we can make consent work in this context. And if not, what are the alternatives?
Since you addressed me directly, I think, quite frankly, the only circumstance I can think about consent being a relevant factor is once systems have been introduced in collaboration with social partners. And once social partners have looked into systems and have defined the scope of their applicability, like Alex mentioned, the question of decision taken by human beings, at least indirectly, or being reviewed, or have an option to being reviewed. So we believe in our part of the world that once social partners have come up with a solution, that it is balanced and agreeable, and therefore it may also be acceptable for consent. But outside of this, I find it quite difficult in the application of AI to talk of a consent requirement and really see this working. Yeah.
I'll make just one point on that. I mean, there is a very interesting Irish Data Protection Commission decision about the prison service, where broadly the unions agreed. Forgive me, I'm not a union lawyer, so I'm using the wrong terms. But the Works Council, the union, had agreed that biometrics was going to work. The Irish Data Protection Commission just simply said no. It doesn't matter about the union, for inverted commas, consent. So maybe I'm not as, we don't use consent much in the UK, but there's the odd occasion where if genuinely someone has a choice, if you were to say biometric facial recognition upon an entry to a workplace, if you genuinely were given still the opportunity to use your swipe card, then possibly there, but it genuinely would have to be a genuine choice with no detriment. And that is a rare beast, I think. So
on the other, I mean, again, we're talking about GDPR, and I go back to the language in GDPR. On the issue of legitimate interest, where does legitimate interest start and stop when it comes to worker privacy? Do you have any interesting examples on this, or any interesting thoughts on this? Anyone?
Sonia, do you want to give it a start?
Yeah, sure. Well, I think the Canadian case law dealing with privacy issues, sort of pre-AI, has really focused on what is the information that has been collected and what is the legitimate business interest that is trying to be protected. For example, is it a security interest? But simply asserting a security interest, for example, or improved business processes has never been enough in Canadian law when arbitrators or courts look at this question of whether it's appropriate. And so there always needs to be a deeper dive into what exactly is the purpose of the collection, what is the harm, if any, and where do you balance the how invasive is the information that is being collected? For example, is it business card information, name, telephone number, etc., or is it something much more sensitive, for example? So I think that we will see that continue in relation to what exactly is the information being collected, how is it being used, the extent to which it can be tracked and traced and that can be identified, but with a deeper explanation necessary about what this information is being used for and why it's being collected in that way will be necessary in the Canadian context.
And I couldn't agree more. Balancing is not a lame excuse for using. Yeah, balancing means that we need to do a real balancing test, taking into consideration the interests of both sides, the interests of legitimate interests of an employer as well as the legitimate interests of an employee. And I think it's less a question on whether the consent was given voluntary or not. It's more a question on the scope of the consent, to what extent and how far does the consent, can the consent be interpreted? Because if we look at the real usage of AI, I mean, it's basically information that is being given to a system that's completely out of the hand of an individual employer. So even if there may be a legitimate interest by an employer for the usage of this generated information, you know, there will be a wider usage, and the wider usage can hardly be assumed to be automatically consented by an employee because it's hardly foreseeable. And that's why I believe there's a gap. In fact, I think on the collection of data that is later on being used for profile building, I think it's really an issue that each of us here on this call, yeah, is being profiled already. And we have no idea where these profiles will be leading us in 3 or 5 years from now. And that's why I've also mentioned that if we look at the wider workplace and children are part of a wider workplace in a good part of the world, we have to look at the protection of minorities and minors in that area in particular, as we've always been doing as lawyers. You know, whenever a new technology was introduced, and if it had been the railway, yeah, we had special groups that needed special protection, and we have to have a look at that.
There was another question in the chat about collective rights of information of workers' reps. And this question was particularly aimed at Canada and Singapore. Are there any legal regulations in those countries on that? And if not, elsewhere, perhaps?
I assume the reference to collective rights is within the context of a union operating, representing employees in a workplace and their ability to require information. And so certainly there are, within the context of labor relations law, there are obligations to provide information to trade unions in respect of new technology work processes. Part of those regulations come from the case law and the legislation, and part of those come from rights that are specifically negotiated between a union and an employer. So a union can certainly negotiate greater access and the greater sharing of information. And certainly we've seen for decades sharing of information where there are technological or process upgrades being contemplated by the employer, and certainly the extent to which that could impact existing employees, including in respect of laying off employees. So there are certainly those existing structures that apply to require the sharing of information.
Rajesh, did you want to add anything to this?
Yeah, sure. Just very quickly, perhaps in Singapore, we have a very interesting tripartite alliance that exists between the government, the union, and employers. And that allows for an amazing level of discourse between the parties in a non-confrontational manner. So in the area of AI in particular, the National Trade Union Congress does take some action in terms of bringing together all the key stakeholders to discuss this issue of the rights of employees in terms of data that's used for processing purposes. But there are no specific laws, just to be clear. It's more a question of dialogue, understanding the risk issues at this point in time. And they are certainly a key stakeholder that the Infocom Media Development Authority looks at in articulating the governance framework that's put in place. So what that means is that employees' rights are being spoken up by the National Trade Union Congress collectively on behalf of all employees in Singapore. We are a very small country.
Thank you, Rajesh. I just want to have one more question for Sonia. Perhaps after that we can close the webinar. It's about, I mean, as an economist, I like this question. It's about cost of regulation to business as opposed to cost of not having regulation, and also cost of having a patchwork of regulation. And Sonia, I was wondering if you had any views on that.
I think it's fair to say that a patchwork approach is never the most cost-efficient approach. It requires legal input from a variety of jurisdictions within one country to form an opinion on whatever the legal issue is that's being presented, and an assessment of compliance with the existing legal principles. So to the extent that and again, most businesses operate in and across the provinces and obviously beyond those borders as well in many cases. And so the extent to which there can be certainty that the standards which an employer operating in one province could be certain that they were meeting the standards in other provinces, as well as hopefully also more broadly in the jurisdictions that they operate, would create economic efficiency and legal certainty. And that legal certainty, I think, creates business certainty. You know, we operate in a jurisdiction that, thank you, United Kingdom, we have a common law system very different than our American neighbors in respect of employment law regulation and their at-will system. And so we very much are in a system where it is constantly subject to change as the common law develops. And so the extent to which legislation has a role in setting out standards and the framework, that is a very helpful place for a business to begin to respond, specifically when considering the introduction of new technology and new work processes.
Thank you, Sonia. And we have now come to the end of our webinar. I realize there are some questions that we didn't answer, but I've been told that some of the speakers will be happy to answer them after the webinar. So I hope the discussion today was helpful in moving from very general discussions around AI to more concrete challenges, and that this is hopefully the start of a wider conversation about AI and privacy in the workplace. With this, I would like to thank all our speakers and our partner, Ius Laboris, for the excellent collaboration in setting up this webinar. Thank you also, the audience, for being with us here today. And I wish you all a nice day, evening, and hope to see you again soon at future OECD webinars. Thank you very much.